We have 3 cases to be presented today on oral argument. We'll hear the first case, which is extended time, and then take a brief recess, and then hear the final 2 cases. And we begin with United States versus McGuire. And Mr. Ebaugh.
May it please the court. Good morning. My name is Nelson Ebaugh, and I represent Ronald McGuire. Because there are so many defendants, I'm going to be addressing the money laundering conviction. Ms. Graf is going to be addressing issues concerning the CCE conviction, and Mr. Volberding will be addressing the summary chart issue. And then finally, Mr. Sherwood is going to be addressing sufficiency and clerical error issues. First, I want to begin with the fact that despite the enormous size of this record, there really was not that much evidence against Mr. McGuire in connection with him picking up cash.
You need to raise your voice a little.
Pardon me. I just want to go over quickly. Thank you. I just want to go over quickly the evidence and the limited nature of the evidence that was against my client, Mr. McGuire. Of course, there was first the traffic stop in July of 2020 in New Mexico. They found a large amount of marijuana in his van. They also found cash. Then the second item of evidence against Mr. McGuire is in August 2020 when law enforcement pulled over Paul Seward. They found an oil change receipt listing Ronald McGuire as the customer. Third, on August 5th and 6th, law enforcement, they did do a search of Mr. Roberts' house and his properties, and they found a backpack containing a firearm and a wallet, and the wallet had Mr. McGuire's name in it. And then finally, the only other evidence that identified Mr. McGuire were the signal messages. There were signal messages reflecting that he was involved in trips to Pennsylvania, to Florida, and to North Carolina. But other than that, there's no evidence that even if he did pick up proceeds from these sales, that he ever returned them to Roberts or to Simmons. In fact, I think it's very significant that the drivers had not. Let me restate that the government claimed in its brief that the drivers had knowledge of the inner workings of the DTO. But it's significant that Roberts disagreed. In fact, there's the signal message where Roberts was telling Blanco, "Would you tell Ash not to be bugging my driver over the money? My driver has nothing to do with it, and I don't discuss business with drivers. It's the less they know, the better." The government also puts a lot of stock into the fact that one of the co-defendants, Terri, that Roberts would front marijuana to Terri for sale, and that Terri would return proceeds to pay Roberts. But you notice that in the government's brief, they don't mention McGuire as somebody witnessing this. And then finally, back to the text, McGuire, it did show that he may have been talking to Roberts about money or drug proceeds. But significantly, there's just no evidence that there was any disposition. I mean, certainly the jury could speculate as to whether Mr. McGuire was involved in transporting drug proceeds and could speculate that perhaps he transferred drug proceeds to Roberts or to somebody else in the DTO. But it just would have been unreasonable for the jury to infer beyond a reasonable doubt that he actually did that.
There was some testimony from one of the co-defendants, I believe it was Mr. Thurman, that explained that the drivers would pick up currency and on those trips would meet up with Eric Roberts. So is it your argument or contention today that that did not include McGuire?
Well, he didn't specifically identify McGuire, and although he may have been talking about, and plus he didn't show that he had personal knowledge of McGuire actually delivering any money to any of the leaders of the DTO. And so this all goes back to Quellar, the Supreme Court decision, where they emphasize that how the money is moved is not significant, at least with the concealment theory. It's why the money was moved. And here, we don't even get to why the money was moved because there wasn't even a disposition by Mr. McGuire to anybody else. There's no direct evidence of it. Admittedly, there's circumstantial evidence of a lot of drivers bringing money back to the leaders of the DTO, but you can't, under these facts, they're just so insufficient as to McGuire to be able to conclude that beyond a reasonable doubt that McGuire actually brought back proceeds to the leaders of the DTO.
I assume that same theory that you just expressed was argued to the jury?
The
lack of evidence or weak evidence as to McGuire?
Yes, it was. Yeah, and there was a motion for an acquittal. Yeah. So, for all these reasons, we're urging the court that it vacate the promotional money laundering conviction and the concealment money laundering. And unless the court has any questions, I'll yield my time.
Yes, thank you, Mr. Ebaugh.
Thank you, Your Honor.
Ms. Graf?
Good morning. May it please the court. Jessica Graf for Eric Roberts. Your Honors, in my limited time today, I will discuss how the district court constructively amended the indictment by inserting 2 elements into the jury charge that were not alleged in the CCE count against Roberts. The government doesn't get to decide which elements it has to unanimously prove to the jury after it rests its case. But that's what happened here, and there are 2 reasons that this court should reverse. First, Roberts preserved error, and second, under any standard of review, the CCE conviction cannot stand. Now, turning to my first point, error is preserved here because the district court knew that the indictment was missing 2 elements and knew that Roberts objected to adding new elements into the jury charge. On page 3059 of the record, during the charge conference, Roberts objected to additional elements and asked that those either be excluded or the CCE count be dismissed. And this court, in cases like United States versus Johnson and United States versus Pinero, has held that a party doesn't have to cite a constitutional violation in order to preserve error, but has to tell the court what the party wants at a time when the matter can be addressed. Now, at first blush, it may look as though Roberts' objection at the charge conference was nonspecific, but context shows that it was, and that is because the problem with the CCE charge had been percolating for days. It first came up at the end of the 4th day of trial, page 2075 of the record. The court asks the government to identify 3 predicate controlled substance offenses for the jury charge. The prosecutor says he'll look into it. Nothing happens again until the 6th day of trial. The court asks again, government, what are your 3 predicate CCE or 3 predicate controlled substance offenses that you intend to use to prove a continuing series? At that point, the government cited pre-Richardson case law and argued that it didn't even have to identify 3 predicate violations. And Roberts responded at that point to the judge that he didn't understand the cases to say that. Later on, the government rests. Roberts makes a Rule 29 motion that the court denies except as to the CCE charge because this matter is still ongoing. And then finally, at the end of the 6th day of trial, in the middle of the defense's case, the court finally says, government, you must identify 3 controlled substances offenses to go in the jury charge. The jury charge must have those elements. And finally, the government identifies 3 controlled substance offenses, 2 of which that were not listed in the indictment. So what did the district court know at the charge conference at the time that Roberts made this objection? The court knew that the CCE has as elements 3 violations of the Controlled Substances Act that the jury must unanimously agree on. The court knew that because during these ongoing discussions, the parties cited Richardson. The court knew that the indictment only listed 1, and that Roberts objected to the addition of 2 more at the 11th hour. So that was enough to preserve error on this point. The judge knew what the problem was and what the defense wanted. But turning to my second point, even under plain error, this court should reverse. First, because the error was plain. Putting elements into the jury charge that are missing from the indictment is a constructive amendment. The government here concedes that their indictment was deficient because it lacked 2 necessary elements for CCE, but then goes on to argue this is just a variance. That's wrong. This court in Dixon held that a constructive amendment occurs when the jury is allowed to convict on a basis permitted by statute, but not charged in the indictment. And this court held in Rubio that when an essential element is modified during the trial, that's a constructive amendment. The government here changed their continuing serious argument from simply conspiracy, as alleged in count 1, to conspiracy plus possession with intent to distribute plus use of a communication device. This is similar to this court's decisions in cases like Chambers, where the government charged felon in possession of ammunition as manufactured by a specific company, and then when it came out during trial that ammunition never crossed state lines, the government changed it to felon in possession of ammunition made up of component parts that were made and crossed state lines. This court held that's a constructive amendment. You have to stick with what you charged. Same in Adams. The defendant there used a fake ID to buy a gun, which had a fake name and a fake address on it. The government charged used a fake name. Then in the jury charge, they added fake name plus fake address. This court said, no, that's a constructive amendment. You have to stick with what you charged. This is not like variance cases where some non-essential element of the indictment was changed. Instead, we have 2 necessary elements that the jury had to unanimously agree on that were not in the indictment inserted into the jury charge. That's error, and it's plain. This error affected Mr. Roberts' substantial rights. First, because it destroyed his right to be tried only on charges that were presented in an indictment and returned by a grand jury. And it's important to remember that what we're dealing with here is a 20-year mandatory minimum sentence off of a charge that didn't provide Roberts adequate notice as to what the government intended to ask the jury to find. And this is exactly what the Supreme Court was talking about in Richardson when it held that the continuing series element, the 3 violations, are elements because CCE is so broad. It can be made up of any controlled substance offense within the code. And that's why it's important that the jury be able to find specifically each element of the offense. We also have to remember here that the government repeatedly misrepresented the law to the district court, saying it didn't have to identify those 3 offenses, and then pivoted at the last minute after it rested its case. Moreover, had this amendment not happened, had this not been included in the jury instructions, the jury wouldn't have been instructed on the elements that it needed to convict, and it couldn't convict. That would be a different outcome. Finally, this affects the fairness, integrity, or public reputation of judicial proceedings, as this court stated in United States v. Griffin. Permitting the district court to second-guess what the grand jury would do undermines the Fifth Amendment and the public's faith in the integrity of judicial proceedings. Your Honors, the government is not allowed to pick the elements it thought it had proven after it closed its case, but that is exactly what it did here. This was a serious error, and under any standard, we ask that this court reverse. Thank you.
All right, thank you, Ms. Graf, and you've saved time for rebuttal. Okay, Mr. Volberding.
You said it exactly right, Your Honor. Thank you very much.
But I messed up Ms. Graf's name, but she
That sounds German as well.
stated it, and I remembered it, so.
Yes. Your Honors, my name is James Volberding. Mr. V is perfectly acceptable. I represent Mr. Sargent. And I rise to address the Rule 1006 summary chart used by the government at trial, which is riddled with basic math errors. This is a preserved error, but in response to the government's brief, please allow me to address the plain error standard straight on. Particularly, the discretionary 4th element established by Alano seriously affects the fairness, integrity, or public reputation of judicial proceedings. And it boils down to 4 words, Your Honor. The math is bad. As we all know, and as this court has warned the government before, 1006 summary charts are some of the most powerful evidence that a jury can receive and therefore require accuracy and care. Here, the math was not simply slightly wrong. It was egregiously wrong. The government's use in federal court of a summary chart riddled with...
They acknowledged that they were guesstimates. Isn't that what the word they used?
Yes. Not a math term I have recognized, but a guesstimate was what the detective said he was doing. Yes, yes. And so a guesstimate, as you indicate, Your Honor, used in federal court injures the reputation of a federal court, which is based on rationality, which is based on accuracy, and, of course, accurate math. I would draw the court's attention to 2 places one place in my brief and one place in the government's brief. I would draw the court's attention to page 23 of my brief and page 30 of the government's brief and ask the court to consider those side by side. On page 30 of the government's brief, the government makes this statement. They, the defendants, can only theorize that Detective Offutt's calculations are wrong. Theorize. The chart is based on verifiable data contained in 3 exhibits with voluminous writings, recordings, and photographs in the form of text messages, signal communications, and photographs. For this declaration, on page 30 of its brief, the government has cites 8 pages in the record. All 8 of those pages are the detective testifying that his summary chart is supported by other evidence. In other words, what the government should say to my response is fine. So the summary chart is riddled with errors, math errors. It doesn't matter. Here are 25 cites to the record for text messages, phone calls, search warrants, and they add up to 15,000 pounds for Mr. Sargent. No harm. But nowhere in its 104-page brief does the government make any effort to whatsoever to identify those so-called cell phone calls or text messages or conspirator testimony that adds up to 15,000 pounds.
Were those calculations directly challenged below?
No, Your Honor. Not my math. My math charts did not appear in the chart below. However, the error is preserved because it doesn't have to be precise. It has to be sufficient to put a trial judge on notice. The objection at trial for all the defendants was that the 1006 predicate had not been made because it was not shown that the chart was accurate. The judge allowed the prosecutor to ask more questions, which essentially became a series of circular logic. Is the chart accurate? Yes. How do you know it's accurate? Because I say it's accurate and it's based on all these documents that we have in the record. I'm standing at this podium today, Judge Douglas, arguing the same argument, which is the 1006 predicate was not made because the chart is not accurate. Now, granted, my argument is a little longer and it has some mouth calculations, but in substance, it is preserved and it is the same. So I will end, subject to your questions, where I began. The math is wrong. And if you look at page 23 of my brief, I make it really clear, I believe, because on page 23, if you accept what I'm saying, based on the record as it comes to this court, it resolves 3 problems that have developed in this case. On page 23, I list 5 transactions of deliveries that the detective says are directly the result of Mr. Sargent. They add up to 829 pounds. I could not find these transactions in the record, but let's assume for the argument they are there. That translates to 376 kilograms of marijuana. That is below the mandatory minimum. So that solves one of the issues if that is the correct number. It also solves the other issue regarding the acceptance of responsibility and the safety valve, because the government insisted that Mr. Sargent tell the truth, and he wants to tell the truth, but the price of that was that he say something untrue, is that he was responsible for 15,000 pounds of marijuana.
What do you do, though, with the admission in court that the quantity was reasonably foreseeable?
the admission that it was reasonably foreseeable. If there's an allegation that's reasonably foreseeable of a conspiracy, then yes, I suppose that cuts against Mr. Sargent. Mr. Sargent, though, for the 1,000 kilograms, is held to be responsible deliberately for that 1,000 kilograms, and my contention is the record doesn't support that, nor does Mr. Offutt's chart support that, because I did the math, and it's there on page 23. The only transactions that link him to that 1,000 kilograms adds up to about 2/3 less, therefore insufficient to satisfy 3 of the problems in this case: an incorrect summary chart, the mandatory minimum, and the safety valve. Subject to your questions, Your Honor.
We agree with you on the errors in Exhibit 190. What is the remedy that you request?
It depends on 2 things. It depends on if you remove the entire chart. You say the chart is so riddled with error, and I'm going to exceed my time, but if it's so riddled with error that then it's a new trial. And it's a new trial because you will not find, unless the government can point to something else, evidence in the record to support all that was listed in that chart. Now, if you contend that the chart is somewhat reasonable, it has some support from the record, but it doesn't reach 1,000 kilograms for my client or some of the other clients, then it's an adjustment of the sentence, you see. And so he would drop from 32 to at least 30, maybe down into 26. It goes back for a safety valve consideration, and the judge will do what the judge wants to do, and he will land somewhere in the mid-20s. Thank you, Your Honors.
All right, thank you, Mr. Volberding, and you've saved time for rebuttal.
Thank you, sir.
Mr. Sherwood.
May it please the court, Gregory Sherwood, appearing for appellant Christopher Sean Regal. My brief raises 2 points, but before I briefly discuss those, because I am here to answer your questions, I want to make sure the court has everything I filed. On July 5th, 2024, I filed the appellant's initial brief. Mr. Ebaugh also filed Mr. Regal's brief. When I read that brief, I then added a July 9th, 2024 Rule 28 letter citing Puig versus Infante. I have copies I can give if needed, but I just want to make sure that...
No, we have all of your Rule 28J letters. So.
Yes, very well. My brief raises 2 issues. One has been conceded or agreed to by the government regarding the clerical errors in the judgment, which state the wrong statutes relating to the money laundering conviction. The other issue I raised in my client's brief was also raised by Mr. McGuire regarding the conspiracy to commit money laundering count. The brief argues that the evidence is insufficient on the domestic promotion money laundering and the domestic concealment money laundering, the 2 issues submitted to the jury. The brief cites the cases on that. I don't have anything to add to that, and I'm ready to answer any questions the court may have.
You didn't raise a Rule 1006 challenge, correct?
I did not in my brief, and let me explain why. Mr. Regal's, and this surprised me when I read the record, Mr. Regal's sentencing range was 168 to 210 months. He received a 60-month sentence, well below the guidelines range and below the statutory maximum. So I could not range, I can't raise an argument about the quantity or PSR objections because it's harmless error because he only received a 60-month sentence. So that's why I did not discuss the summary chart or the issues raised by the other appellants. My client has no harmful error on that point. If there's no other questions, I'll appear again for rebuttal. Thank you.
Yes, you've saved time for rebuttal, and since you haven't used all your opening time, you can have 2 minutes for rebuttal. You had requested 1.
Thank you.
All right, thank you, Mr. Sherwood. Ms. Hagan?
Good morning, Terri Hagan, excuse me, for the United States. May it please the court. The drug trafficking organization that is at the heart of this case is substantially different from most of the drug trafficking organizations that we see. To be sure, it started out as your typical drug trafficking conspiracy with Mr. Simons and Mr. Roberts purchasing marijuana from California and Oregon and then bringing it back to Dallas, selling the marijuana and collecting their payment. But as the demand for marijuana on the East Coast of the country grew, then the distributors, the sources of marijuana in the West Coast, needed a way to ship their product to all of those states on the east side of the country, 21 states in all. And that's where this drug trafficking organization evolved. They began picking up the marijuana in California and in Oregon and shipping it across the country. The sources would pay Eric Roberts and Nick Simons for their transportation. And as the business went further along, the organization began picking up drug proceeds that would ultimately go to the sources in the West Coast. But the record is very clear that before the drug proceeds went to those sources, they went to Mr. Roberts, and that before Mr. Roberts sent the proceeds to the sources, he took out his cut. So he took out his profit, and that included the amount of money that he paid the drivers for their services and the amount of money dedicated to expenses, transport expenses, including things like gas, hotel, food, tires. And if there's any doubt that that's the way that this drug trafficking organization worked, then I would direct you to Exhibit 246, which you can find at page 9482 of the record, and which was discussed with the witness at page 1289. That exhibit is a single-page, handwritten ledger sheet written by Mr. Roberts. It details 5 different trips that were being taken at a discounted price. And in my brief, I talk about this exhibit at page 66, and I need to correct a typo there. The total profit that you can see from the exhibit that Mr. Roberts calculated was $69,600. Immediately under his calculation, arriving at that figure, he calculates the amount of money that each of the drivers would get and the amount of expense money. And there's also, an entry for tires. So the expenses totaled $16,500. On the ledger sheet, he subtracts the expenses from how much they would receive, and he arrives at a profit of over $53,000. He takes that number further out and writes divide by 2. And in doing so, he says that he will get $26,550, and then Mr. Simons would get the same amount. So that's probably the strongest evidence of promotional money laundering. But on top of that, you have phone conversations between Mr. Roberts and Wickham Simons, who was one of the California sources, and Mr. Simons says to Mr. Roberts, essentially, and this is at page 1446 of the record, Exhibit 213D, page 105, Mr. Wickham says, "Hey, are you sending me $50,000 back?" And Robert says, "No, because I paid the driver from your pickup." That explains right there. In addition, you have Mr. Wickham Simmons in another conversation at page 1423 telling Mr. Roberts, as long as you just took out what you needed for the TP, it should be good. As far as additional evidence of promotion, at one point there's a signal communication where Mr. Wickham Simons asked Mr. Roberts, "Hey, can you make 2 additional pickups?" And Robert says, "Well, maybe, but it will cost you." And Mr. Simons says, "Well, that's okay, just tell me how much, because if you're able to do this, then we'll get another customer who will do an additional 2 boxes weekly." And that's at page 1432 to 33. Addressing Mr. McGuire's claims specifically, there are more conversations between Mr. McGuire and Mr. Sargent than those that we detailed in our brief. In fact, there are a total of at least 10 conversations between Mr. McGuire and Mr. Roberts, in which Mr. McGuire says things like, Mr. Roberts says, "Are you bringing paperwork tonight?" And Mr. McGuire confirms, "I gave the cash to the guy." Mr. McGuire at page 108 said, "So 2 paperwork jobs?" And Robert says, "Meatball and Taz." And McGuire says, "Yeah, and Jimmy." So then Robert says, "Yes, so 3, but Meatball has 2 stops." And McGuire says, "Paperwork then, pickup." And Roberts confirms, "Yes." There are also discussions between the two at pages, this is Government's Exhibit 212, at pages 109, page 114, page 122, page 128, page 133, page 139, and page 142. So Mr. McGuire was knee-deep in this, and the record is clear that he was bringing the drug proceeds back to Mr. Roberts, and then, like all of the other drivers, collected his fee from those drug proceeds. I'd like to move on. Before I do, just in conclusion, the evidence is clear then that there were transactions with drug proceeds that were sufficiently different and separate from the drug sales. So the evidence is overwhelming of promotion, money laundering, and of course you only have to find either promotional or concealment. And also, we stand on our assertion that there was sufficient evidence for concealment based on Mr. Simon's testimony. The jury could infer that they were trying to hide the source and the ownership of the funds by not using financial institutions and by transporting the drug proceeds in the manner that they did.
And is that enough for concealment?
Yes, because it shows not only how they were transported, but why. So it does comply with Cuellar.
And your argument is that the why is what exactly?
The why is so that they did not get caught. That was Mr. Simon's testimony. He said specifically that they did not use financial institutions to avoid detection. But you don't have to get there if you disagree with her argument, because, as I said, the evidence of promotional money laundering is overwhelming. So let's get to the charge then. There was no pretrial challenge to these charges, nor was there a challenge to the accuracy of the charts. Mr. Roberts objected solely on the grounds of predicate, and even his voir dire questions went to the source of the information, the underlying data that the officer, the investigator, used to create the charts. So review is not for abuse of discretion. Review is for plain error, and the court did not commit plain error by admitting those charts. Any error, and we submit there was none, was certainly not clear or obvious. I believe it was you, Judge Smith, that pointed out that at one point, Investigator Offutt said a guesstimate. Well, that testimony was specifically directed at the unknown weights. So, Investigator Offutt explained to the jury that the average weight calculation was based on trips we are sure occurred. That's in the record at 642 to 44. He also said that he absolutely got the amount right. And as to the weight, he again affirmed that his calculations were based just on what we could accredit in the actual data. The prosecutor did go through in front of the jury many of the entries on Government's Exhibit 190, the summary chart, and matched some of those entries up with communications between Roberts and the driver. So for Mr. McGuire,
Do you
yes.
dispute that some known delivery values were excluded?
The way that they were included is after the investigator added the number of known weights and divided by the number of trips, that gave the average weight. So the unknown weight are the remaining trips by the drivers where there was no discussion about the quantity of marijuana that was part of that trip. So that's what he meant by a guesstimate. So using math, he would have assigned those trips the average of 506 pounds and multiplied 506 pounds times the number of trips that each driver took. So that's what he was referring to. And as I was saying, the prosecutor went through some of the entries on the charts, some of those phone conversations with Mr. McGuire. He went through Exhibit 212, which has some of the communications between Mr. Roberts and Mr. McGuire. Exhibit 203 was some of the conversations between Roberts and Sargent. Exhibit 198 was some of the conversations with Regal. And then exhibits 209 and 210 were some of the conversations with Mr. Roberts and Mr. Lala. Now, during cross-examination, Mr. Lala's trial counsel did ask the agent, well, where is the evidence of this 66 pounds and 6,000 marijuana cigars? And the agent said, well, I can't tell you off the top of my head. And so counsel said, why don't you show me over the break? They did that. And when the investigator testified again, he cleared up the misunderstanding. And he showed Mr. Lala's attorney that that quantity came not from a conversation between Roberts and Lala. It came from a conversation between Roberts and Blanco, and that's at page 1765. So that little discrepancy shows, number one, it's kind of a double edge here. It shows that the jury was alerted to, well, the source of the information was Mr. Roberts' cell phone, but it wasn't a conversation with the driver. It was a conversation with the source. And that actually makes our point here that you cannot find error in those calculations unless you look at the universe of the information that investigator Offit relied on, and that was the phone extraction report and the phone, and those were in evidence and available and were all produced before trial. And even if there was any error, summary charts are not required to be error-free. That's just one defect in a trial if it occurs, and we are not confessing that it occurred. We stand by the charts. But in this case, the three curatives that the Fifth Circuit has imposed to show that a summary chart is not prejudicial where it contains errors are met. First of all, the facts support the assumptions, the extraction report, and the phone support the charts, and appellants have not shown that it doesn't. Second, the witness was subject to extensive cross-examination about the calculations, and each defense counsel argued that the calculations were wrong in closing argument. And finally, the court gave the jury instruction telling them to give the charts only the amount of weight that they believed it deserved. So there was no error in admitting the chart, and the evidence sufficiently supported the jury's verdict to drug quantity. First of all, they had the chart. But in addition to that, they had other testimony. One example is what Mr. Roberts said during his proffer at the United States Attorney's Office, and the jury heard this. He told investigators that one single source, Mr. Blanco, sent 500 to 1,000 pounds of marijuana a week. The indictment charges that the conspiracy went on for 2 years and 11 months. And if we do the math, we will see that even using 500 pounds from that single source, that adds up to 17,500 pounds, which is 7,937.8 kilograms. So there was a lot of other evidence that supports over 1,000 kilos. In addition to that, Mr. Seward, who testified, was stopped with 1,000 kilograms during one of his trips in Kansas. So a rational jury in this case could find that both the overall conspiracy and each of the defendants were responsible for over 1,000 kilograms. And as Judge Douglas pointed out, they could also consider what was reasonably foreseeable during the course of this conduct. And that's the same for Judge Mazzan when he sentenced these men at trial. Mr. McGuire, Sergeant, and Lala say that the court clearly erred in assessing the quantity of drugs to them. But that's not true, especially giving the court the deference, the considerable deference to which it is entitled, that the findings were plausible in light of a whole. The court, the sentencing judge, sat through the 8-day trial. He found the evidence credible. He adopted the pre-sentence report, which included the calculations from the chart. In addition to that, the amounts that the court attributed to these men was very, very conservative. The pre-sentence report showed that a conservative amount of the overall conspiracy was 23,460 kilograms. That's marijuana alone. It does not include the illegal THC edibles and THC oil that were charged in the indictment. And additionally, Mr. Roberts' admission, which I just went through with you regarding how much marijuana Blanco provided, supports the court's determination. Finally, any error would have been harmless, especially to Mr. Lala, because Judge Mazzan said that even if he calculated the quantity wrong, he would still impose the same sentence for everything that happened. And for Mr. Sargent, he received the mandatory minimum 120-month sentence under count 1. So if the jury sufficiently found that quantity, then there was any error would have been harmless, and it wouldn't have been an error at all because Judge Mazzan had to make his finding only by a preponderance.
They have also been harmless to the others. You spoke specifically to Lala and Regal, but what about the others?
In light of the jury verdict, it's harmless. The other one, I think, was Mr. McGuire, and the court held him responsible for a minimum of at least 3,000, but less than 10,000 kilograms. And the evidence that we've discussed, especially concerning the number of trips that Mr. McGuire made in his extensive conversations with Mr. Roberts, supports that finding. So going to the continuing criminal enterprise, the proper standard of review in this case is plain error. Mr. Roberts, as we pointed out in our brief, did not move to dismiss the indictment. And under Rule 12b-3b-3, before trial, he should have moved to dismiss the indictment for a lack of specificity. He didn't do that. Under the old rule, he would have completely waived that error, but under the rules as revised, the standard of review is plain error. So, contrary to my friend's representation that the government misrepresented what it was required to prove, the error, the deficiency in the indictment is plain today. But Mr. Roberts' trial began on January 9th, 2023. And while Richardson was decided in 1999, what the majority opinion said was that the jury had to unanimously find the three predicate violations. Now, the dissent did suggest, well, then that makes some elements, so the government has to allege it. But that was in the dissent. And admittedly, the Justice Department advised prosecutors to charge those three predicates. That wasn't done here. So the indictment was deficient. In fact, though, it didn't become clear until 2024 in Montague, when the Second Circuit said the indictment should have alleged all three predicate violations. So that's why it's plain error. So let's start at substantial prejudice to Mr. Roberts. We refer you back to the harmless error test, which he has to prove that he was substantially prejudiced. So really, there are two questions, certainly turning to the second one first. In this case, the grand jury would have returned a proper indictment had the one been presented to them. We know that because they only needed to find probable cause, while the petit jury in this court case found beyond a reasonable doubt that Mr. Roberts had violated each of the three predicates. So turning to notice, the record shows that he did have notice of the violations. It reveals that he knew how critical it was for the government to establish that he was the one using his cell phone to further drug trafficking. He asked at least 6 government witnesses at least 15 times whether their communications could have been with someone other than Mr. Roberts. He asked our witness, don't you know it's true that someone else could have been sending those messages? The technology allows it. And then in closing, he argued that there was no proof that he was the one that used the cell phone. He argued more than that, but I need to move on to constructive amendment. In this case, the indictment said, in very general terms, that Mr. Roberts had committed one underlying offense, count 1, but not limited to that violation. So, as the Supreme Court pointed out in Richardson, the Controlled Substance Act is 2 sections and about 90, 2 chapters and about 90 sections, and it adds a lot of other crimes, a lot of violations. So when the court narrowed the jury charge and instructed them that they could only convict Mr. Roberts for CCE if they found that he was guilty of not only count 1, but possession of a controlled substance and use of a communication device, the court narrowed the indictment, and as we pointed out, the evidence was overwhelming. See that my time has expired, so I'd like to end with thanking you for giving us the opportunity to present our position. Thank you so much.
Hagan. For rebuttal, Mr. Graf? Ms. Graf, I'm sorry. Ms. Graf?
Your Honors, 2 points on rebuttal. First, as to the standard of review, the government argues that plain error applies because Mr. Roberts did not move to dismiss the indictment pre-trial under Rule 12, and that in any case, the indictment was sufficient at least until the government conceded in a Second Circuit case in Montague that they needed to include all 3 predicates in the indictment itself. Now, leaving aside long-standing precedent from the Supreme Court and this court that an indictment must allege every essential element, none of that matters when it comes to the constructive amendment argument. A motion to dismiss the indictment pre-trial is not required because a constructive amendment doesn't occur until the trial itself. So all of that has nothing to do with the constructive amendment argument that I'm talking about today, because that happened when the 2 new elements were added to the jury charge at the charge conference. Roberts' attorney objected to those being added into the jury charge, and that was done within the context of repeated conversations with the district court about the fact that the government had failed to identify those 3 elements that it needed to. Now, turning to the government's argument on
Even though it was known to the defendants earlier on that there were not three predicates?
It is, Your Honor, because those are 2 separate issues. Now, the defendant could have argued earlier on that the indictment should have been dismissed for being deficient, but that's still a separate issue from constructively amending the indictment at the charge conference by adding those 2 elements. And when that is done, that is structural error. The government argues all of this is harmless because they had so much evidence against Roberts and he was obviously guilty. That has nothing to do with this court's analysis on harm. Instead, what the court should look to is the fact that he had no notice of, as the government stated on page 2689 of the record, 80 transactions which would be used by the government for this charge. Thank you.
Thank you, Ms. Graf. Mr. Volberding?
Thank you again. Thank you, Your Honors. I'll make 3 points very rapidly to some of the questions. I would draw the court's attention to page 26 of my brief. On page 26, I've explained how the fraction was gamed. We talked about the 506 average. It's not difficult to game a fraction if one plays with the denominator and the numerator, and that is what I've explained happened here. It's a good indication that if you compare over to page 23, where I list a handful of transactions associated with Mr. Sargent, they are much smaller than that. The fraction was gamed. Number two, second point, I want to draw your attention to tab 6 in the record excerpts. I see the packages on the counter. Tab 6, I have the summary chart. And on page 24 of the summary chart, you're going to see a large number in the right-hand column that throws off this fraction, 6,446. 6,000 pounds of marijuana, it appears. I looked at the reference in the record. I don't understand how the 6,000 pounds was resolved. I cannot answer that question for the court. And lastly, I want in the same tab 6, I want the court to please take notice of the bait stamp on the document. It's dated, it's bait stamped with a number of over 190,000. I cannot speak to the number of discovery documents produced in this trial, but it appears it was more than 200,000 pages. And at the 190,000 page, apparently, is a chart that is not labeled a summary chart. And fortunately, the defense lawyers dealt with that as it arrived. Thank you for the opportunity to appear.
Thank you, Mr. Vogel. Mr. Sherwood?
Your Honors, the government argued that the evidence on promotion money laundering was overwhelming. I mean, all I can say is it wasn't, and that's really all the rebuttal I have. I can point out that I agree that the evidence was sufficient, that Regal's conviction for a drug-related conspiracy was proven. What's always concerned me about these types of cases where we have one conspiracy and then money laundering conspiracy is I've always questioned, well, is the government just trying to create two offenses out of one? Well, the evidentiary record has to show the two separate conspiracies. But again, to me, the evidence against Regal showed a drug conspiracy, a drug-related conspiracy, but just not a money laundering conspiracy. If there are no other questions, I join my colleagues in thanking the court for allowing us to come argue our clients' positions. Thank you.
All right, thank you, Mr. Sherwood. The court notes that Mr. Sherwood, Mr. Volberding, and Mr. Ebaugh are court-appointed, and we wish to thank you for your willingness to take the appointment and for your good work on behalf of your clients. Sometimes with these multiple defendant cases, the oral arguments are pretty disjointed and ineffective because people have such a short amount of time. But I appreciate all of your working together to divide up the arguments and to make them effective for a good presentation to the court. With that, your case is submitted, and we'll take a short recess before hearing the next case.